charges under the Indian Penal Code and thereafter proceed accordingly in light of the observations made by us in the instant judgment. Before parting, we would like to clarify that the observation and the opinion made by us in this judgment is pertaining only to the aspect of framing of charges and must not be construed to be any opinion on the veracity of the same, which is required to be proved in trial in accordance with law. This appeal is accordingly partly allowed.
Again, 41. Yes, versus
We agree with the opinion. Writ petition is dismissed.
142. Chabia against Sabia Begum versus Media.
No case for invocation of tertiary jurisdiction is made out. Writ petition is dismissed.
43. College ages graphically versus Media and 5.
Impugned opinion is upheld. Writ petition is dismissed.
May I please your lordship? Lordship, I beg to mention item number 12, lordship. Kindly adjourn for a day.
Well,
Yes, lordship.
this matters you can do online. We are encouraging not to come to the court because of the situation. We understand if a lengthy hearing you may have difficulties. Adjournments and all these matters you can try online. At least on Monday and Friday, even on other dates, we are encouraging that purpose. You can make a request, whether we grant or not, that's a different matter. Only the mode has been changed. It's not that we are not doing matters. We'll do matters as usual. The mode of hearing would be has slightly changed. Item number
12, lordship.
12 is of which year? Or 26? Okay, 26 you could have mentioned online on the behalf of the petitioner.
Yes, lordship.
Halima Begum.
Yes, lordship.
When do you want?
Lordship, next week.
On a request made on behalf of the petitioner, matter is adjourned to be listed on today's on 1st of June,
Highly
1-6.
appreciate.
Malaysia, back to item number 10, my lord.
10. 20 matter. Yes.
Can this matter may be taken on 1st of June, my lordship?
20 matter. Why 1st of June? Why not today?
The there and Islam is not well, my lordship.
You can do the case, Mr. Day.
I have not, file is not with me.
Then Wednesday. A request for adjournment has been made on behalf of the petitioner. Para. List. Accordingly, list on Wednesday. Wednesday is Wednesday is open. 27.
Thursday.
No, Wednesday. Wednesday is open.
No, Thursday is holiday.
Yes. 27.
May it please your lordship, I beg to mention for the listing, the mention
Listing of new matter.
new matters, lordship,
Fresh.
fresh. Filing number 5846
Okay.
of 26.
When did you file?
22.
22nd of May.
Yeah.
Okay, you can have it whenever you want. Day after tomorrow.
Okay, lordship.
My lord, appeal number 3 and 7 may be adjourned for that day.
3 and 7 are all matters, madam. 19 matters. Why are you seeking adjournment?
For next week.
No, not next week. Why are you seeking adjournment?
Yes, sir.
Why are you seeking?
I am on behalf of M Hawk. I'm not on the record.
We understand, but why are you seeking the adjournment? What is the difficulty today?
A personal difficulty.
Personal difficulty. Friday? 3 and 7 on a request made on behalf of 3S Hawk Learned Counsel for the petitioner. Matter is adjourned to be listed on Friday separately, huh? 3, alag, huh? 29. 3 and 7, 29. Okay.
Yeah, please, Your Lordship. I beg to mention item number 11, Your Lordship. Here, Your Lordship, it's a old matter, but a file is missing from my chamber, Your Lordship. We have applied for the certified copies of the entire brief, Your Lordship. So, Lordship, may kindly Friday or next, not Friday.
Okay, Friday.
Next week, Your Lordship.
Friday.
I'll be not available, Your Lordship. I forgot, Your Lordship. Next Monday, Your Lordship, kindly.
Ms. G. Bora has submitted that the file is misplaced and the same is being reconstructed. Full stop. She accordingly prays for an adjournment. Para, in view of the above, matter is adjourned to be listed on 1st of June,
Lordship.
1/6.
Most okay. Your Lordship, I beg to mention item number 14, Your Lordship.
1/4.
Some
Yes.
relevant, Your Lordship, some relevant documents left out, Your Lordship. We would like to file additional affidavit.
Matter
Your
of which year?
Lordship. It is 26, Your Lordship.
Okay. Ms. G. Bora, Learned Counsel for the petitioner, prays for and is granted 2 weeks' time to file additional affidavit. Para, matter is accordingly adjourned to be listed on 8th of June
Much obliged, Lord.
to enable filing of additional affidavit. 8th of-
Item 1.
May I please, your lordship, my lord. We have challenged the impugned order, that is page 86. But before going into the judgment order, let me show certain exhibits.
Yes, just a minute, please. The judgment as which page?
Is 86.
86.
All boys.
Sahita.
Now exhibit kindly see.
Just 2 minutes, just 2 minutes. FT Baska. Baksa. What is your date of birth or year of birth?
That is not specifically mentioned, but it is.
Year of birth.
Para 4, page 4, para 2.
What would be the year of birth? If you deduce from the age disclosed in the affidavit?
It appears on 52 years on July 19.
So what will be her age?
July
age?
19. 52 years. So it will be 19, 20. 59. 59 around. 59 around 58, 59. 59, 68.
No. Year of birth will not be 59. She is 50? 52
52 in 19.
in 19.
52 years in 19.
So it'll
Close at
be,
90.
still be around 70 what? Huh?
19.
Hmm?
67.
1967. Okay.
Now, he has given categorical statement that the paras 4, para 2,
Hmm.
that she was born and brought up at village Katajhar.
Okay, let us see the documents, then you wanted to see the
Yes.
documents?
And that is first document is voter list of 1955, page 19. In the name of his grandfather and father.
Her, not his.
Yeah. The name Alim Sheikh is her grandfather.
19, 19 is not a certified copy.
Yes. That is not certified copy.
19 is not a certified
Yes,
copy.
but it is in the voter list. But it may be seen page 22. That is the chita in the name of her grandfather, Alam Sheikh, page 22.
Page 22.
Yes. Exhibit 1.
Alam Sheikh.
Alam Sheikh, yes. Village Katajhar. Exhibit 1.
Grandfather,
Grandfather.
village Katajhar. Okay.
And Exhibit 2, the voter list of 1970, page 28, in the name of her father, Hassan Ali.
29 is the vernacular.
Yes,
1970 voter list.
70.
Who's there?
Hassan Ali. is
Father.
my- Hassan Ali is my father.
Okay.
Then voter list of 1985, page 30.
What is the endorsement after this voter list? Can you read the endorsement at page 29?
Page 29. Yes, Hassan Ali, Pita Alim Sheikh. Malika, she is not relevant. Relevant is Hassan Ali.
No, no, what is the endorsement? These are not names. Something has been written. Can you read, Mr.
This certified copy, my lord.
Understood. No, no, what is there? At page 29, in the vernacular after the names, normally we do not find any endorsement of this nature.
Alim Sheikh. Hassan Ali, son of Alim Sheikh. উপরোক্ত তালিকা তলত লিখা অনুযায়ী কৌণিক নম্বর 21 ঘর নম্বর 19 ঘর নম্বর তারিখ ভোটারের নাম আর পিতা মাতা বা স্বামীর নাম জমথাতে তিরতা.
Okay, okay, doesn't matter. Let us not be
Is there
bothered.
explanation of my lord, serial number 1, 2, 3? What's it?
Explanation has been given, but
This should generally, my lord, it is not written generally in the certificate copy, but in voter list, it is always there right below in page 27, your lordship may kindly see. The last serial number 1 is serial number, 2 is house number, 3 is voter. This should be
Oh,
explained.
oh, yes, yes. Normally in certificate
In
copy is not
certificate copy, it
written,
is not given.
but okay, okay, doesn't matter. Then you give 85, Mr. Mahmood,
yes, 85.
is page 31.
85, page 30.
31.
Vernacular is at 31.
It's Sabiran Nasa. It is in the name of my mother, Sabiran Nasa.
Mother,
Mother.
Hasan Ali.
Hassan Ali, it should be. Hassan Ali, it is written like the
Sabiron Nessa is the mother.
mother. And father's name is written Hassan Ali. It is Hassan Ali, should have been.
85, your father is not there.
According to record, I think so.
When did he pass away?
That is also not written. That is also not written. It's
This will go against you.
Whereas,
Please check whether you have made any statement
yes, six.
when your father had passed away.
Here, page 6, kindly see.
Yes.
Page 6, para 5. Here it is in a petition expressed that the father of the petitioner along with his family has shifted again from village Bongshibari to village Shimaluburi, PS Tamulpur in the district of Nalbari. Sometimes in the year 1979, and since then they have been residing in this village. The father of the petitioner has expired after 75. After 75 died. So in the voter list of 85, his father's name is not there.
This you have made statement in paragraph 4 of the written statement. Which you have just read, which paragraph?
Para 5,
Of page
6.
of the written statement.
No, in the case.
Okay, page 6.
Page 6.
No, in the written statement, not in the written petition.
I have not gone to that still now.
We are
WS, the Lordship may see the WS, page 57.
57.
Yes, 57.
After paragraph 12. 58, paragraph 12.
Yes, 75. Now, Lordship may kindly see the voter list of 1997, Exhibit 4, page 32. Sabiran Bibi and Sabiran Nessa, these are the same men. Normally after marriage, Bibi is written. So my mother's name appears in the voter list of 1997.
But see her age.
Her age is written
70 years.
70 years.
How can you relate this Sabiran Bibi?
That is the reason. That was also one of the reasons shown by the learned tribunal. That we have explained in page 9, para 10. Page 9, para 10. Explanation regarding the anomalies in ages and names. And it is also surprising that in the year 1997, her age is written, page 32 as 70 years, and 2006 also 70 years. Page 34. So these are the mistakes committed by enumerators. because these are certified copies.
Page 35 is 2006.
Page 34 is 2006.
Come to the vernacular.
Yes, vernacular, page 35. Age is written as 70 years. And 97 also 70 years. Then 2009 is the voter list of 2009, page 36. Age is written 74 years. It is my mother's name. Age is written as 74 years.
Okay.
And Hassan is her father.
Hassan is her father. Then Lordship may kindly see.
But where is your name?
Yes, it is coming later.
67 born. Your name should have been there long time back.
But it is not exhibited, so my lord, we did not annex here. Now kindly see page 2016. A voter list of 2016, page 38.
39. This is exhibited,
Yes, it is exhibited.
not exhibited. Not certified copy. This is not a certified copy.
It's not certified copy by electronically generated copy.
No, it has to be certified. Electronically generated has to be certified. Others are also electronically generated.
No, well, that is also acceptable in law. Electronically generated voter's list or any document is also admissible in evidence. To that extent, I have citations.
Without certification.
Certification is not necessary. The signature of the thing issuing authority is not necessary.
So it has to be electronically generated. Where is it written that this is an electronically generated document, signature is not required?
It's written like
That disclaimer is always there in an electronically generated document. This is a simple photocopy.
it's written like that.
Photocopy, it is photocopy.
This is not electronically generated. That's a different thing. You are correct. Nowadays, many of the transmission are electronically generated. Signatures are there. There is a disclaimer that no physical signature is necessary.
Yeah.
Here it's not there. This is not admissible. But nonetheless, what do you want to show in this voter list?
Yes, I want that here Moto Ali is here.
Who?
Moto Ali is my brother. And he is DW2.
Brother.
Yes.
Page 38.
Page 38.
But where are you till 16?
No, I am not here. In 16, I am not here. I am not here. Later on, I am coming, my lord. Now, Exhibit 7, ID card of my mother, page 40.
Epic.
Yes, Sabirun Bibi Hassan.
Epic of your mother.
Yes.
These are not relevant. Just show the Chabiran Bibi.
Relevant means what? These are also public document. That's why some importance should be given. Then, my lord, 2006 is the voter list in the name of the petitioner, page 44.
What about this 2000 and 1997?
No, there is not we have not got.
Hmm?
We haven't not got her name.
No. Shaitan is there.
Shahitan.
Shaitan is there in 97. Why are you leaving out 97? At page 43? Her name is there.
Her name is there in the 97. Separately, we have annexed.
No. You are going to page 44. Why don't you come to the previous
That
page.
is with her husband's name. Sohitan, it should have been written as Shaitan.
Doesn't matter. So this is the petitioner, according to you.
Petitioner with her husband.
Okay, page 97, page 43.
42, 43. Yes.
43, 1997. Voters list. Soitan.
And so 2006, Sohitan Bibi again, with husband's name, Abdul Majid's name.
One of the most, 40. This is 206, 45. Sohitan. Okay. In 97, you were aged 41 years. In 2006, you were aged 40 years. But without those discrepancies, it may be the mistake of the enumerator. If you are aged 40 or 41 in 97, where are your previous voters list? And more important to that, where is your link with your parents?
It is coming later on because this Mota Ali, he is my brother, he has adduced evidence.
No, that is not a link.
And
Documentary link.
directly there is no document. I found.
Difficult. So, Mahmoud, difficult.
Then kindly come page 45, Sohitan Bibi Abdul Majid with husband.
We have seen 40.
Now
Her age is 40
46.
years.
Then 97, that is also with husband. Exhibit 8, page 42.
Yes,
Then
42 we have already seen.
yes, then 2006, 44 you have lordship has seen.
Yes.
2009 has seen. Now in 2013, page
2009 we have not seen. 2009 we have not seen. Page 47.
yes, 46, 47. Yes.
2009 voters list. Sohitan. Bibi. 44. Yes.
Then 48, it is Sohitan with husband, Abdul Majid. That is also
Uncertified.
the
Hmm. Then
my lord, PAN card with father husband 50, page 50. This is linkage. Hassan Ali, Sohitan Bibi, father's name Hassan Ali. Page 50. So it is linkage, and it is also is there. But in the 2013 voter list, without any page 48, without any reason against my name, there is letter D, page 48. There is no reason.
serial number.
Serial number 616. So though letter is D is there, but it implies that I was present in the soil of India at that time. Then Lordship would say the revenue clearance certificate in the name of my mother. Kindly see page 52. 52. This is the revenue clearance certificate in BTC. My mother's name is there as Pattadar Sohitan Bibi.
Where is your mother's name?
Page 52, serial number 1. Pattadarar naam Shukur Ali, Moto Ali, Sahira Khatun, Sohitan Bibi. Pitar naam Hassan Ali. So, Moto Ali is here. And his father is my father is same. That is Hassan Ali. It is
Yes.
also a linkage.
This Mozadar had come to depose. Minati
Yes,
Pathak.
yes,
She is deposed
yes.
as GW.
2.
Yes.
Then VCDC chairman, page 54 and 55.
54.
Yes. That is exhibit 13. Here, Sohitan Bibi, daughter of late Hassan Ali. So this is also a linkage. It is exhibited document.
What is VCDC?
VCDC Village Council of Defense Committee. Village Council Defense Committee. In BTC area, it is there.
This chairman has deposed.
Yes, no, chairman has not deposed. But the revenue authority has deposed.
As DW2.
No, as DW3.
No, revenue you have said 2.
No, Moto Ali is 2.
Motor, the revenue is 3.
Revenue authority is 3.
Okay.
Now, Gauhati certificate, exhibit 14.
Exhibit
14, Gauhati certificate, page 55. It is exhibit 14.
Your husband is there.
Husband's name is,
No, his husband is there or not?
here we do not say husband's name. Father's name is there.
No, no, we are just asking whether your husband is alive.
the decision after 75.
No, no, husband. Not
Oh,
father.
Yes, alive.
Husband is alive.
Alive. Abdul Majid Khan or Abdul Majid.
is it?
Where have you, is there any statement?
No,
That is
the
alive.
name it appears page 2. Petitioner's name, daughter of late Hassan Ali, wife of Abdul Majid Khan. And from the voter list also, it appears that her name is with her husband always.
Yes, after 54.
WS page 57.
Just regarding the Gauhati, can you just again?
Yes, Gaura's certificate is page 55.
56.
56 is a vernacular.
Yes, vernacular.
Yes.
10/1/19. Exhibited,
No, it is not exhibited.
not exhibited.
No, it
No,
is exhibited, but
exhibited.
Gabura has not adduced evidence. Exhibited, exhibit 14. The Gabura has also certified that I am the daughter of late Hassan Ali. And he knows her very well. So these things are there, contents should be taken into consideration. Then WS page 57. In WS mainly, I have taken the stand that there is no proper investigation. Allegations are false. Then para 5, I was born at village Katajar under PS Sarvok, lately Borpeta Road in the district of Kamrup. And she was brought up at village Katajar. This is clearly written. And about 32 years ago, she got married to late Abdul Majid Khan. Oh, sorry, my lord. Her husband also died later on. Opi is the daughter of late Hassan Ali and Musammad Sabiran Bibi. Her grandfather's name is Alam Sheikh and late Rub Bhanu. Her grandfather was son of late Hura. The father of the Opi was only son of her grandparents. She has two brothers, namely Shukra Ali and Mutu Ali, and three sisters by name Shahira Bibi, Hafiza Bibi, and Halima Bibi. This Mutu Ali is my brother, and he is the Diduli too. Then in para 8, she got married with Abdul Majid Khan of Shimlabadi under PS Tamulpur in the district now Baksa, Assam, and produced 3 numbers of children by name Jabbar Ali, Laili Begum, and Juhuruddin. There was no case against her relatives, and she has changed over address she has given in page 58, para 10. The OP, her parents, and her forefather or firstly residents of village Katajar under PS Sarvok, Borpeta in the district of Kamrup, Borpeta, Assam, and about 45 years ago, her parents, including her, shifted for better livelihood to village Shemalabari Bari under PS Tamulpur in the district of Kamrup, lately Nonbari and now Baksa. So in para 12, she has given detailed description of several voter lists. And in para 14, she has given the description of the exhibits.
Yes.
And up to in para 14, 13 exhibits she has exhibited, all are written here. It is verified. So thereafter, she has submitted her evidence on affidavit,
Page.
page 66. The same thing which she has stated in her WS, almost the same thing. But here Lordship would say the cross-examination part.
Yes, please.
Page 76. It is not a fact that my forefather and I came from Bangladesh. That Alam Sheikh was my grandfather, whom I have never seen. I do not know about brothers and sisters of my grandfather. That Rubhanu was my grandmother, whom I never saw. My father was single child. I have 6 brothers and sisters, namely Shukra, Motu, Sahara, myself, Hafija, Halima. I have 3 children, namely Jabbar, Laili, Jahuruddin. I am a Muslim by religion. None of my family members involved in any foreigner's case. Now kindly see the quality of cross. Nothing is demolished. What she has stated, see, everything remained as intact. By oral submission, that can be destroyed. They will only submit orally that this is that. But in cross, there is nothing adverse against me. Then Lordship may kindly see the evidence of my brother Mutu Ali,
Page.
78. And let's see para 3 onwards. I know the Opi by her name as Mosama Sohitan Bibi because she is my own sister. That I and Opi are son and daughter of late Hassan Ali, firstly resident of Katajar, PS Sarvok, now Govardhana in the district of Kamrup, now Baksa, and once Borpeta, Assam, lately resident of village Simulwari, under PS Tamulpur in the district of Baksa. Then 2 brothers, Shukra Ali, Mutu Ali, these are the same thing. He has repeated that there are 6. Opi was given marriage to Abdul Majid Khan, resident of village Simulwari. She was born at village Katajar, under PS Sarvok, Borpeta Road, Govardhana, respectively, and district Kamrup, Borpeta, Baksa, respectively, and brought up partly at mentioned locality and partly at Simulwari. That being the daughter of my father, Hassan Ali, the Opi is not a foreigner but a citizen of India. My father was deceased about 46 years ago at our lately shifted residence at Simulwari under PS Tamulpur, district Baksa. So now let us see his cross. Page 82. I have produced electoral photo ID card as identity. Shohitan Bibi is my sister. Let Alam Shok is my grandfather, whom I have never seen. So I do not know whether my forefathers came from Bangladesh. Let Rubhanu was my grandfather, whom I never saw. My father was alone. Shohitan married about 33 years ago. Now, I do not know whether my forefathers came from Bangladesh. Now, here is one thing. Alam Sheikh is his grandfather. And from the history of the case, if even it is, though not admitting, he has come from Bangladesh, he is not a foreigner because at that time India was united. Now, the evidence of DW3, page 84. It is from Revenue Department. My name is Jagannath Pal. I reside at village Jabli Bil Pathar, PS Govardhana District, Baksa. My occupation is assistant helper in Govardhana Mauja. I am an assistant helper in Govardhana Mauja and authorized to appear before the tribunal by Maujadar Srimati Minati Pathak, filed letter dated 15/2/19, submitted here on her behalf. Exhibit 12 was issued by Maujadar and Exhibit 12(1) is her signature. The exhibit was issued on the basis of records where Shohitan Bibi is a co-pattadar as daughter of Hassan Ali. As per Jame Wasil register of Kataj RPA in pattern number 65, the name of Shohitan Bibi is recorded. Cross. There is no record of from when the revenue is collected and when the land was mutated in the name of Shohitan Bibi. The register was copied from records of Latmandal recently. I have not brought the records of Latmandal as I am not authorized. Now, there is no value of this cross. So far my case is concerned, because when the revenue is collected and when the land was mutated in the name, so it is a matter of record. And he is not the Mandal. He is the assistant helper in Govardhana Mauja and he was authorized by the Maujadar. So cross is not adverse against me. Now, impugned order, page 86. The learned tribunal has discussed the exhibit, page 87, bottom. In support of her contention and oral evidence, she exhibited certain documents as documented evidence. Annexure 1 is copy of NRC. Exhibit 1 is certified copy of CITA of 1958. That is annexure, it is exhibit. Exhibit 1 is the CITA of 58-59 village Kartazhar, bearing name of Alas Sheikh.
Yes.
Alas Sheikh, it would be, I think, Aram Sheikh, my grandfather. Exhibit 2 is the certificate copy of extract 1970 electoral roll relating to 47 number Sorbog LSC, wherein village Bangshibari elector Hassan Ali, son of Alim Sheikh, as 40 years are found written. So this Hassan Ali is my father. And this is the voter list of 1970. Exhibit Annexure 3, let us go to Exhibit 3.
Actually, the observation by the learned tribunal is correct. It is not Alam, it is Alach. You come to page, the vernacular at page 23. This is alos. Mr. Payang. Alos, not alum.
Yes,
It's not alum, it's alos.
Alos Sheikh. Alos Sheikh. Pita Sheikh. Yes. My lord, the names, this is very difficult because from our experience, we have seen the Muslims' names cannot be written easily by the enumerators in almost every document like that.
No, no,
But thing
alos
is
can
this-
be alach. Alos cannot be alum. More cannot be so.
This is Alim Sheikh. There are 60 voter list. It is Alim Sheikh, son of Fura. Here,
Alos.
Alos. So certificate of extra voter list is Hassan Ali, son of Alim are written.
But your translation is not correct. You should not have written alum at page 22.
Yes, that is as per the vernacular. Now, page 88, Lordship kindly see. Exhibit 4 is the certificate copy on 1997 voter list relating to Tamulpur LC, wherein village Shimolobari.
We have read the opinion. What are your submissions?
Yes, negative opinion, my lord. Then the learned tribunal has discussed in para 11 about Motu Ali evidence.
Correct.
Para 11. Motu Ali, as about 60 years, son of late Hassan Ali, resident submitted his evidence on affidavit as witness number 2 of proceeding, where he deposed that, inter alia, that opposite party is his own sister. They resided at first village Katajar and later on shifted to village Shimolbari. He repeated the version of the opposite party during cross-examination. He deposed inter alia that he never saw his grandfather, Alam Sheikh, and his grandmother, Rubbanu. He does not know whether his forefathers came from Bangladesh. Sohitan married about 30 to 33 years ago. So nothing is there, my lord. Nothing could be demolished. And para 12, Jagannath Pal. He appeared as deposit party's witness number 3 and deposed, interrelated that he is assistant helper Govardhana Moja office, and by letter dated so and so, Mojadar Srimati, Miniti Pathak authorized him to depose on her behalf. Exhibit 12 was issued by Mojadar. Exhibit 12-2 is her signature. The exhibit was issued on the basis of records where Shohitan Bibi is a co-patradar as Hassan Ali in Patta number 65 of name Shohitan Bibi is recorded as serial number 12 in Jama Wasil register of Qatar. During cross-examination, he deposed inter alia that there is no record showing from when the revenue was collected and when the land was mutated in the name of Shohitan Bibi. These are, I think, irrelevant observations because when land is collected, that is not relevant so far FT matter is concerned, foreigners matter. Now, para 14, as per police inquiry report, it appears that the learned tribunal has given very importance to the police inquiry report. Actually, that is not the piece of evidence. That is only for studying the proceeding. Main thing, my lord, he has discussed para 19. Sorry, it may be seen. Para 17. I am therefore of the opinion that the proceeding opposite party has not been successful to prove her citizenship from the relevant period. She entered into India illegally after 25th March 1971 from the specified territory. Where he got it? where the tribunal got that I have entered after 71. It is only his presumption. Now, 18, the reference stands disposed by answering the question in negative, holding that the proceedee opposite party is a foreigner. Now, my lord, if you see, this reference stands disposed of by answering the question in negative. In negative means, as I think, my lord, the state has alleged that I am a foreigner. Now, in negative means positive, that means I am a citizen of India. Maybe it is grammatical mistake. But from the reading of para
The
18,
immediate question from this court would be, why have you filed this writ petition then?
no, yes, we have because later on it is,
You have also understood what is the meaning.
yes, but from this sentence, it appears so. If the reference,
Wrong use of expression.
yes,
It should have been affirmative.
yes,
Meaning is the proceed.
yes, it should be affirmative, my lord is correct. But it is negative means in my favor. Now,
So you can withdraw the writ petition and let the state file
no,
a
I
writ
am
petition.
saying that because
State will file a writ petition thereafter.
other contents are against me. So, here, my lord, it appears the proceeding, para 19, proceeding opposite party therefore is liable to be pushed back to the specific territory. This is also illegal content, illegal order, because the tribunal is entrusted with the power of opinion. Now, deletion of names, it will be pushed back. These are the works of the state. So, the learned tribunal has traveled beyond its mandate. Now, here, the as has been taken very seriously, and the here in para 16, after 2 lines, the proceeding suffer from multiple material contradictions rendering the same highly improbable. In such circumstances, it cannot be that the proceeding had discharged her burden as required under Section 9 of the Foreigners Act. Now, my lord, this Section 9 is taken very casually by the learned tribunal. The evidence of the proceeding, her brother,
Motu Ali,
and revenue staff, they have stated they have exhibited the documents in the name of Shohitan Nasa along with the name of Hassan Ali. And Hassan Ali's name is there in the voter list of 1970. Village Katajar and Shimulbari. Districts names are different. Borpeta, sometime Nolbari, sometime Baksa. That is the political decision. So, except the anomalies in names and ages, I could prove my case. Now, my lord, recording of my name or putting the age, these are not my job.
Okay.
These are the jobs of enumerators, government officials. Now, in so many cases, my lord, in Abdul Mutali's case, the Honorable High Court in division bench said that because of differences in names and ages,
Abdul Mutali.
Abdul Mutali, 2015, 2 GLT,
Mutalib.
Muttali.
M-U-T-A-L-I.
M-U-T-T-A-L-I.
M-U.
M-U-T-T-A-L-I.
Mutali.
Yes.
Mutali. What is the citation?
I am saying after my understanding. So here you go. Maybe not pick it up today. Now, and also the case of Sirajul Haq. Sirajul Haq, I'm coming to that point. So, because of difference in names and ages or change of residence, change of residence is a universal phenomenon, madam. A person may have a residence today at Dhubri, tomorrow he may go to Dibrugarh or Gauhati. So these are not the factor which will prove that I am a foreigner. Differences of names and ages, these are the handiwork of the enumerators. Burden of proof in such type of case is like preponderance and probability. Preponderance and probability, just like civil case. It is not a criminal case, the proof beyond reasonable doubt. But this section is always misused. For instance, I will give some two citations for your lordship, my lord. 2001. Yes. 2001 4 SCC 375 para
Name.
Sucha Singh, SUCHA. Sucha Singh versus State of Punjab.
Para.
Para, my lord, 19. Now,
What proposition?
yes, I am submitting. Moment. We pointed out that section 106 of the Evidence Act is not intended. 106 and section 9 are same. Of the Evidence Act 106, yes, ma'am. Lordship may go to Evidence Act. Earlier Evidence Act. Because something is specifically within the personal knowledge of the person concerned. 106 of Evidence Act.
Things within exclusive knowledge.
Which within the knowledge of the.
Yes.
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 But section 9 is different. Section 9 is named.
No,
not
these are relevant sections. These are relevant sections.
Yes.
Now here, Honorable Supreme Court is saying that we was missing perhaps. We are pointed out that section 106 of the Evidence Act is not intended to relieve the prosecution, the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt, but the section would apply to cases where the prosecution has succeeded in proving facts for which a reasonable inference can be drawn regarding the existence of certain other facts, unless the accused, by virtue of his special knowledge regarding such facts, fail to offer any explanation which might drive the court to draw a different inference. Now, here, my lord, a proceeding has said, I have taken birth at village Katazhar, Moja Govardhana, PS Borpeta Road. Then it is now Govardhana, PS. Earlier it was Borpeta district, now thereafter Nalbari, thereafter Baksa. She has said that my grandfather is so-and-so, but I have not seen him. My father is Hassan Ali, he is dead. My father's name 70 voter list is there. Cut-off date is 1166 to 25/371. So before 71, my father's name is there. Now the PAN card, the land document, evidence of revenue staff has categorically said, and it is a reflecting document that my father's name is Hassan Ali. My brother Motu Ali has given evidence that our father is Hassan Ali. They could not demolish anything. the revenue authority gave evidence, they could not demolish it. So here, I have discharged my burden to the possible extent.
But how is Suchaching
Yeah.
helping you?
You know,
How is Suchaching helping you?
helping you means does not relieve the prosecution. You know, the honor shifted to state. When primarily I have discharged my burden, then onus is shifted to state. What they have done? Only because a foreigner's case has been written, has been initiated, and you are foreigner. That is not the law. Now, what they have done? Now there are differences in names, ages in some places. Have they said that it is a false document? No.
Yes, we'll have to consider Suchaching. This was not cited earlier. We'll
Yes. Then that's it. So, my lord,
you have done many
19 lordship has seen.
You have done deep research, it seems.
Not deep research. And this Mutal is
Mr.
cited,
Payang,
my lord.
this has not been cited earlier.
Abdul Muttalli's case of the 2015, Abdul Muttalli's
Yes, 2000.
15, 2 GLT 617.
2 GLT 617.
Yes.
Paragraph
Paragraph 10 and 14.
10 and 14.
10 and 14.
And you had also cited Sirazul Haq,
Shirazul Haq.
Kematullah Kafatullah.
Yes.
2018.
Let me see. Shirazul Haq.
2018.
2019.
19.
5 SCC 534.
2019, 5 SCC.
Yes. 534. Para I have written here.
Paragraph 3.
Yes.
Para 3.
Para 3. Now, the burden of proof. Here, again, another section.
Just a minute, please. One. Yes.
Now, 2016, 12 SCC,
Regarding
burden of proof. 2006, 12 SCC, 306.
12 SCC 206.
Yes. Para 13 and 14,
Name
Bikramjit Singh,
B
alias
or V.
V.
Vikramjit.
Bikramjit Singh, alias Vicky. First,
JIT or
VICKY.
No,
First.
Vikramjit is J-double-T or JIT?
JIT.
JIT. Okay. 2006 12 SCC 206.
306.
306.
Yes.
Okay.
Versus State of Punjab.
Okay. What is there?
Yes. Then kindly say para 13 and 14.
What has been stated?
Yes, I am submitting. In the instant case, there are two versions. The learned session judge proceeded to weigh the probability of both of them and opined that the appellant having not been able to prove its case, the prosecution case should be accepted. In our opinion, the approach of the learned session judge was not correct. The High Court also appeared to have fallen into the same error. It invokes Section 106 of Evidence Act, although opining the section is not intended. These are very important sentence. This section is not intended to relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt, but the section would only apply to cases where the prosecution has succeeded in proving facts from which a reasonable inference can be drawn against the existence of certain other facts, unless the accused, by virtue of his special knowledge regarding such facts, fail to offer any explanation which might drive the court to draw a different inference. Section 106 of Evidence Act does not relieve the prosecution to prove its case beyond all reasonable doubt only when the prosecution case has been proved. The burden in regard to such facts, which was within the special knowledge of the accused, may be shifted to the accused for explaining the same. Of course, there are certain exceptions to the said rule, that is, where burden of proof may be imposed upon the accused by reason of a statute. So there is statute, Section 9, but the principle of law is always there. So in other words, Section 9 and 106 is the same. Only that has been brought in Foreigners Act, Section 9, because that is an special act. And a detailed explanation, detailed procedure may not be written there, because it is the work entrusted to tribunal. Tribunal need not go into depth of the case. But in the name of not required to go into depth of the case, very casually a person is declared as foreigner. That is not acceptable in law, because that is the most precious right of a citizen. And suspicion, however grave may be, cannot be substituted or proof. In para 15 is also written. So they suspect to be foreigner. Why? Names are somewhere different, age are somewhere different. It is your work. You have not denied the authenticity, veracity of that document.
Okay.
Now you want all the benefit. And unfortunately, the benefit has been also given by tribunal. Tribunal should have adjudged the matter in a impartial manner, in accordance with law. But they have said something, tribunal has believed this. No law is discussed. Onus is shifted to the Muslim Wonders case, when the proceeding has discharged his burden. Onus shifted to them. They have not adduced any evidence. Not, though crossed, nothing is demolished in the evidence of the proceeding. So, my lord, in my humble opinion, they have miserably failed to shift, to discharge their onus. I have another citation. That is 2006, 6 SCC 94 para 84.
Name?
Name Standard Chartered Bank versus Andhra Bank Financial Services Limited.
Bank is.
Yes. I am on ratio.
84.
84, yes. Rebutting this arguments, Mr. Jetmalani contends that section 1110 is contained in chapter 7 of Evidence Act 1872, which deals with the burden of proof. As a matter of fact, section 110 merely enunciates the burden of proof as to ownership. He rightly submits, my lord, the apex court is saying, he rightly submits that any rule of burden of proof is irrelevant when the parties have actually laid evidence and that evidence has to be considered. Reliance is placed by him on Sitaram Bhau Patil versus Ramachandra Nago Patil for the proposition that when the entire evidence is before the court, the burden of proof becomes immaterial, even assuming that the rule of burden of proof in section 1110 is relevant. So he says that when the parties have laid evidence, the tribunal or courts will see the evidence. Now, what is the quality of my evidence? Only evidence is not enough. Quality of evidence. So, I have discharged, I have submitted WS. Exactly, I have submitted my evidence on affidavit. My brother Motu Ali as DWT has submitted his evidence. Both the evidences are closely related with each other. There is no contradiction. Thirdly, Revenue Authority says Soitan Nesa, who is my mother, her name is in revenue record. They have not disputed that. None any voter list they have disputed, nor by demolishing the evidence through cross-examination. Now they will say, no, she is foreigner. That is not the law. Then the person must be a very well expert in law, only that person. There may be some lacunas, I understand that. But whether that lacuna will make me a foreigner. So I hope and believe that your lordship would kindly consider this part. And recent judgment of Honorable Supreme Court, my Lord Rahim Ali, that is a very long run discussions have been made. Judgment MD Rahim Ali, Ilyas Abdul Rahim versus State of Assam, 2024 INSC 511. Lordship may kindly note down the 2024 INSC 511. Here addresses critical issues concerning the burden of proof.
How do you spell Rohim? R-O or R-A?
R-A.
Rahim Ali, 2000
Mohammed Rahim Ali.
2024 INSC 511.
511, yes. Entire case is regarding various aspects of the foreigners case. And
We have dealt with Rohim Ali. Rohim Ali has not taken into consideration the larger bench of Sarvananda Sonwal. Rohim Ali is a two judges bench.
yes.
Sarvananda Sonwal, paragraph 43, entire 43 has been overlooked. Perhaps it was not brought to the notice.
But actually, what I understand, subject to correction, law is the last words passed by the last judge. Now, session judge, judicial magistrate first class has convicted a person, Mr. A. It is set aside, annulled by session judge. That now the prosecution came on appeal before the Honorable High Court. High Court has acquitted them. So the last word is the High Court. Letter. So the law is the last sentence or word passed by the last judge. Now, Sarvananda Sonwal's case, my lord, that was due to another background. There was an allegation that lakhs of foreigners are coming into Assam and they have changed the demography of Assam. But the census report does not say this. Last
No,
time,
Mr. Mahmood, we cannot go to criticize Sarvananda Sonwal
No,
or
I-
Rohim Ali.
that was the allegation.
See,
That
we
was
are
the
only,
allegation.
only pointing out that Rahim Ali decision is of a bench of 2 judges,
Yes.
wherein Sarvanda Sundar, a bench of 3 judges, observations have not been brought to the notice. Perhaps it was not brought to the notice. Otherwise, if
no,
43
my
was brought to the notice,
No, my lord. There was a judgment, there is a judgment of our Supreme Court. The law declared by the Supreme Court cannot be forsaken by any authority of India, including the highest authority, including high courts, on the point raising that this attention was not drawn to that point. It is binding on all. Now,
larger bench will be ignored now.
all authorities.
Larger bench also.
No, larger
What is
was,
the judicial discipline?
no, I am submitting that. Then in such a situation, what is the law? Then the matter may be referred to Honorable Chief Justice. He may constitute a larger bench or full bench. But
That can be done by the Supreme Court, not by us.
yes, yes. No, as
See,
a,
you are also
in
bound,
Supreme
you are
Court,
also,
if
you are
you-
also as an officer of the court, we are on the bench.
no,
also
yes,
bound,
you cannot, in,
bound by a
yes,
larger bench.
yes. That is the job in Supreme Court, Chief Justice of India, in
Correct,
High Court,
correct.
Chief Justice of High
We
Court.
will consider. we'll consider.
So, my lord, my submission is this. Even if we forget about the judgment and ratios of Rahim Ali and Muhammad Abdul Rahim,
Hmm.
my learned friend on law point may say at best some High Court decision, but is in Supreme Court, I think he would not be able. He would not be able. So, Supreme Court, he may say, but what is the,
So you are prepared to go to the Supreme Court.
no, I am not, because we are poor men.
How do you know what he'll say in the Supreme Court?
Normally, what my learned friend normally submits, there are differences in, there are also some differences in the judgments of division bench of our High Court. In such, I mean, Lordship is aware about that. I am telling the truth. But that is also the question.
You always speak the truth. When have you doubted that you do not speak the truth?
Now, that is also a question that the judgments given by one division bench, if it differs to another division bench,
We have understood your case, Mr. Mahmood. You say there are cogent evidence by 3 numbers of
Yes.
DWs,
yeah,
including the that Mozadar's person
Yes, yes.
and the brother Moto Ali.
yes,
Moto Ali's name has appeared along with the father,
yes,
so link is established.
yes.
And the evidence adduced by all the 3 have not been able to be demolished by the other
Right,
side.
rightly observed.
That is
Exactly, exactly.
Yes,
So, my lord, may kindly give it. Now, my lord, I am going to court number 22. I have a matter there. If your lordship kindly permits, I may go.
can we stop you? know, If there's
Madam-
anything, we'll ask your assistant
Yes.
counsel.
22.
But you have done extensively. I think it's covered everything. But here, Mr. Pine,
In the Muslim Motors case also, I argued various points which were relevant at that time.
yes, yes.
But nowadays, again, situation has changed. So, some new things are coming. Oh, nice one.
First of all, I'd like to go to the WS matter, because the entire point here.
WS is at page
Page
50.
57.
57.
Right, copy. So, in WS matters, I just want to point out one thing that from the entire WS, the Lordship may kindly see. They're relying on the document in evidence. And during, even before this honorable court also, that there is a revenue paying receipt of the mallet, which is produced, which is proved by the mallet, the assistant of the, that.
Mozadar.
Mozart, assistant of
Madam, take your seat.
Mozart. So, the state facts, mallet, that the petitioner had a land, or his father, her father had a land, and she had occupied that land or inherited that land, that part is not pleaded in the WS. If we see para-wise mallet, I mean, the last. So that is not there. Even the document was not annexed at the time of my lord. All the other documents were annexed. And page 59 is other documents, my lord. Page 59 it is better. Page 59 to 60, these are the documents. 18 documents they annexed during evidence, during WS. Filing of the WS, but this document was not annexed. In fact, this WS was filed from the record. It is this WS was filed on 26th day of November 2018.
26?
Day of November 2018. Page 64, madam. What transpires, madam, the document which they have annexed. The land revenue paying receipt.
Yeah. Right. That one.
And this receipt was done 15/11/2018. And this
15/9. Oh, 15/11.
15/11/2018.
Oh, yes, yes.
And WS was filed just after 1 week from then. The WS was filed on 26th day of November 2018. Even then, my lord, this tax was not treated before the treatment. WS. That is the first point I would like to point out, my lord. And however, this was stated in the written statement, my lord. During evidence, he has given evidence at page 69 is the my lord evidence. Page 69. What he has stated in page 69, evidence 24, para 24. This is evidence. Evidence was filed on 9th day of January 2019. Para 24 is the statement with regard to this document. What she has stated that as daughter as well as heir of my father, late Hassan Ali, I obtained along with my brothers and sisters a plot of land bearing patta number so and so, and wherefore we have paid revenue clearance certificate on 15/11/2018 as the plots of land have been situated in Katajar, Moja so and so in the district of Baksa, this Masan. So what she has stated, madam, she has got this plot of land and they have paid revenue for this plot of land. But she has nowhere stated, madam, this land was occupied by her father and she has inherited this by way of inheritance. Or this land was mutated in her name by way of inheritance. That statement is not.
She said, I obtained along with my brothers.
Yes,
And
obtained.
then heir of my father.
Yes, obtained, my lord, how it is obtained.
That-
Yes.
And
How it's-
heir is not written. Oh, as well as heir of mine.
Yes, legal heir. No, my lord, first of all.
Yes,
so
right, good.
why I'm saying this, yes, obtained. Why I'm saying this, my lord, there is no land record of the projected father. The land which was exhibited, my lord, as exhibit 1, that is in the name of grandfather. That is in the name of grandfather. The exhibit 1. So there is no statement that that land was later on inherited by her father. Then they have inherited that plot of land. Another aspect is there, my lord. She has stated in her evidence as well as WS that from that original village, Katajar, they have shifted in 1973 to the present village.
Yes, please again.
Yes. From this Katajar, well, but they have paid land revenue in 2018. From this Katajar, according to them, according to the petition, the family shifted in 1973 to a new village, to another village, the present village, at Simulubari. Simulbari.
Okay.
They have shifted 1973. Here. Page 58, my lord, para 10 it is said. In WS. Page 58, para 10 it is said, OP, her parents, her forefathers were firstly residents of Katajar, Tolbuk, Road, so and so, Assam. And about 40-45 years ago, her parents, including her, shifted for better livelihood to the village Samulbari under PS Samulpur district. So if this deposition was in 2018, so if it goes back 45 years, then it will be 1973 approximately. So 1970. So they have shifted from that place. Now they are saying in 2018 that we have inherited that, we have obtained that land. And there is no land record from the evidence itself, evidence of DW3. And it is clear that the DW3 did not bring any record to produce that he has that to show that the petitioner has any land record in hand. Now only issue remains whether the land revenue paying receipt. This is a land revenue paying receipt. This is a evidence. In fact, in entire even in civil also, land revenue paying receipt will not provide any right to the petitioner in any manner. Even this honorable court has said, madam, the land revenue paying is not a proof of citizenship. That there is clear finding, clear. So this land revenue quick receipt, my lord, apart from not disclosing the same in WS, even though it is brought into evidence.
Are there any citations you're relying upon?
Yes.
Now, what we are also thinking aloud is that this 52 certificate, this is a certificate only for the purpose of acknowledging receipt of revenue.
Yes, ma'am.
Law is that land revenue certificate will not declare the right of title.
Yes, ma'am.
And here we are on a much serious issue, not only title over the land, we are on the issue of citizenship. Can it be construed to be a proof?
No.
When it cannot even be construed to be a proof of title over the land,
That
can
is
it be held to be a proof of citizenship? Even a chita or a jamapandi
Yes.
can show the lineage if appropriately proved. Now here, this land revenue certificate received from whom, for what purpose? There are many other intricacies involved in a land revenue certificate.
That's why, madam. So that's why it is land revenue paying. It is clearly said land revenue paying received do not prove a citizenship of a person.
What is it?
This is my lord, please. It is WPC 7451 of 2019, my lord.
745119.
2019.
Name disposed of?
Zabeda Begum, man. BEDA, Zabeda Begum.
BDA, Javeda Begum.
Yes. Disposed of on 12/02/2020.
12 February 2020.
Yes.
Repetition number can create.
7451.
74.
7051. 7451.
7451.
719. 7451.
Second last paragraph is going to clearly say land revenue being received do not prove citizenship of a person. Therefore, we find that the tribunal has correctly appreciated. So that specific line is there. So if that, and even if we see the evidence of DW3 also, what he has said in cross part, he said even in
Page.
page 84, madam. In fact, he's not the Mujadar.
He is the assistant helper.
Assistant helper. Man.
Yes.
In Gauhati, Moja and authorized to appear before the honorable court. A tribunal by Mujadar so and so, submitted here with exhibit. Who is this? The exhibit was issued on the basis of record where Saritan Bibi is a co-partner of so and so. As per Jamia was registered. As per Jamia was still register of Katajura Patan number 65, the name of Sultan Bibi. So it will be recorded at serial number 12. Yes, her name may be recorded in Madam. I am not on that. But whether she have inherited or whether she is the daughter of Malat Hasina, that is what Then he said, there is no
Mention
record.
The Soitan being the co-patadar as daughter of Hassan.
Yes, as that,
As daughter.
how Patadar as daughter of Hassan. Yes, Malad, there are numbers of Patadar in that case. In that Patta. And she is one of the co-Patadar. Her husband, father name is shown as Hassan Ali. That is true. But who is that Hassan Ali? We don't know. So whether that original Hassan Ali, whose name was there in 1965, she inherited that plot of land. There is no record, right below the cross, there is no record from when the revenue is collected, when the land was mutated in the name of Sohitan. This is very important. Because the proceeding initiated just before this revenue is paid. 2016, the proceeding initiated, the case initiated against the petitioner. She has paid this. The register was copied from record of Lat Mandal recently. I have not brought the records of Lat Mandal as I am not authorized. So he cannot say anything. What is there in the record? And it is settled position, but the record, the document has to be documentary evidence has to be documentary evidence has to be proved. Document has to be proved on the basis of records, contemporaneous record available in the office.
And one more aspect in this connection, if you come to the, let us try to test whether the land mentioned of the grandfather
Yes.
is also this, is connected to
Same-
this land.
same land or not?
Kindly come to page 23.
23.
Apart from the discrepancy in the name of the grandfather, you see there, this is Exona. On the right, fourth column, this is Exona land. Have you
Yes.
found?
Exona.
Exona on the fourth column.
Yes.
Exona, whereas this, and there is no reference to, obviously there is no Exona, there is no patta. There is dag here at page 52. There is a dag, there is a patta number,
Yes.
65 of Kheraz Miadi.
Yes, that is why, madam.
So you cannot connect this land,
Land to that plot of
even
land.
assuming that land, father's name is not there, but grandfather's name is there, but it's not connected to that land.
That's why I'm saying, madam, para 24, page 69. That's why, madam, I pointed out page para 24 of the evidence. What is her statement with regard to this plot of land and with regard to that revenue, land revenue paying? She has not stated that the said plot of land of her grandfather was inherited by her father. Then they have inherited that plot of land. Those statements are not there. She simply said that this paras 24, page 69. This is very important. There is no positive evidence that the land occupied by the grandfather was inherited by the father. Then they inherited. This statement is not there. So in absence of that, we cannot presume that the petitioner has inherited the same plot of land apart from these discrepancies. So that is the point, madam. If this document is not there to link herself, and as I have said, revenue paying receipt will not prove of citizens, and this land revenue is paid after initiation of the proceeding. Cases started when not after receiving of notice, just before filing of the WS, they have paid this land revenue. And it is not mentioned in the WS, which is very important, not pleaded in the WS. So if that is not there, other two documents, the one Gaugura certificate, two Gaugura certificates were there, those were not proved. Page 19 and page 18. These were not proved by the These were not proved by the Lat Gaubura. Apart from the Gaubura certificate being melon, the national emblem is posed on the top of this certificate. These certificates were not proved.
What about the VCDC?
VCDC is same as Gaubura.
Huh?
Same as Gaubura.
VCDC is Gaubura.
Yes. They are-
Chairman? No, no.
It's like Village Defense Party. but
Defense
it's a
Party.
private organizations. It's a association of the village.
Yeah, VDC, it's called VDC, Village Defense Committee.
Village Defense Committee.
Committee. But will it have the authority to give a certificate on citizenship?
VCDC is in our village, in our area, but VCDC is in PTD, this is VCDC.
Okay.
So they provide security to the village.
What is the full form? VC?
Village of Village Council Defense Committee.
Chip, it's Village Council Development Committee.
Village Council Development.
Lodge.
Or not VDC, it's different.
Maybe.
Development, you may be correct. Madam may be correct.
It's like, yes, chairman, yes.
Village,
Yes.
village what?
Village Council Development Committee.
Committee.
Yes. They are in absence of consent, they are doing this. They are doing this.
Okay.
So it is like the consent certificate.
Hmm.
It will be treated like consent certificate issued by the secretary of the consent. But it cannot be issued by the chairman. Chairman cannot issue because chairman is like the president of the Gaon Panchayat. He cannot issue certificate. If certificate has to be issued, it has to be issued by the secretary only, not by the chairman. Because he's
But in
elected.
any case, chairman did not come to the witness
Chairman
box.
did not come to the witness box. He did not prove this document. So exhibit
And
13
it,
and 14.
but what about the Gaon? There's, even if you say it's a VCDC, Gaonbura is not there. Oh, Gaonbura may be there.
Gaonbura is there. Gaonbura is there.
Oh, the Panchayat is not there. Panchayat is not there. This Gaonbura also, Mohan Rajbangshi did not come before
Did
the.
not come. He also did not depose. So they did not prove both these documents. Now, in absence of both these documents, my lord.
No, that
There
part
is-
Mr. Mahmood has very fairly said that they did not come to the box. He is
Yes.
banking upon first the land document,
Land document.
number two, the witnesses of brother Moto Ali,
Yes.
and third, the evidence of the assistant helper.
Assistant helper, my lord, as I have already pointed out. He has said nothing. He has said there is no record in his office. And whatever records are there in the mandal, so he could not prove it. So he could not prove the document on the basis of any record. So second thing is, my lord, with regard to the another aspect, my lord, and has not argued that one. This only voter list. Yes, after 1970, my lord, the page 28 is the voter list of 1970.
Page,
Page 28, my lord.
wait.
Yeah.
Yes.
It is the voter list of 1970 of the projected brother.
Hmm.
Projected father. And here, my learned senior relying that my lord, Sirajul Haq, whereby it was said that the minor discrepancies can be ignored. But the rider was there, my lord, as I have pointed out, that the other names should be consistent. But here, my lord, only in 1970, it is only Hassanal in village Bansibari. Now, the next voter list is 1985. of her projected mother, my lord, Sabiron Nessa. And Sabiron Nessa was 35 years in 1985. So neither Sabiron Nessa nor this Hassan Ali, my lord, voted together in any voter list. Now, their claim is that, madam, that the age of Sabiron Nessa in 1997, it is 70 years. This may be ignored because there may be discrepancies, and this is but the enumerator who has, in fact, there now, madam, this Sabiron Nessa becomes Sabiron Bibi in 1997. The age discrepancies of Hughes, 35 becomes 70. It's unusual, madam. And same thing there in 2006, Sabiron Bibi. And the husband name is also some extent different in 1985. It is Hazen Ali in 1985. Not Hassan. Hazen Ali. So my submission is that, my lord, even though there is minor discrepancies in the name
The argument on the other side is that these are discrepancies made by the
enumerator,
Yes. But your argument is that these are literal
Yes.
discrepancies.
and relied on the judgment of my lord, the Abdul Matali.
Matalib.
Abdul Matali, my lord.
Hmm.
That has been relied. That has been distinguished by this.
Basiron.
Yes, Basiron. In Basiron, it is distinguished.
What is the citation of
Basiron,
Basiron?
my lord, 2018, 1 GLT 372.
Basiron Nessa.
Yes,
3-7.
Basiron Bibi, sir.
BB.
Yes. 2018, 1 GLT 372.
2018, 1 GLT.
372. There it is said, my lord. Para 30. Reliance placed on the case of Abdul Matali can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decisions that the said decision did not lay down any law as well as a decision confined to the facts and circumstances of the case. Regarding discrepancies in the voter list, which the petitioner contended were not her creation, being entered into by officials of Election Commission, and therefore should not be used adversely against the petitioner. Such contention is without substance. The voter list were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portion of the voter list which are in her favor should be accepted, and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to appreciate that as a whole. Document has to appreciate. Now, my lord, because the voter list of 1997 contained the name of Sabiran Bibi as wife of Hassan, that may be accepted. And because the age may be ignored, age 70, it is not my part, it is not my fault, that may be ignored, and this part may be Sabiran Bibi, wife of Hassan, may be accepted, cannot be done. This argument cannot be accepted. It has either it has to be rejected as a whole, or it has to be accepted as a whole. That is the point settled by this. And along with that, Sirajul Haq, had there been other names in 1970 and consistent in 1997, 1985, 2006, then it would be a different issue. But there is no other name in the voter list except single person name there in 1970, here also in 1985. And there is a vague statement that the father died prior to 1970. When did? It is not. This is always vague. So, this is the main issue, my lord. And projected brother has come. Projected brother has come, my lord. That I have already cited the numbers of occasions, my lord, that oral evidence of the brother, mother, or sister, mother, father cannot be accepted as evidence unless there is documentary evidence to prove that they are linked with each other or they are or linked with the petitioner had a link with.
Mr. Mahmood had argued that Motu Ali had a link, had a document to link
Mother.
with Hassan or Sabiran.
That
And
is,
therefore,
that is the land document. That is the.
not land, there is a voters list also, I think.
Motu Ali has no link documents along with him and the father. Motu Ali has no link document with his father. Probably there was a voter list of 2016 month. Page 38. This is the only documents. Motu Ali.
16, uncertified, uncertified, page 39.
Yes.
That is uncertified.
Yes, it is uncertified. Secondly, my lord, this is linked with Motu Ali to Sabiran Bibi. Motu Ali in the petitioner has to be there. Then Motu Ali to my lord, then only it can be accepted. This is uncertified. This was not exhibited before the trip. Now the second aspect, my lord, the learned senior friend has.
Oral evidence, what citation? Noor.
Yes, yes. 2020, my lord, 3 GLT 347.
20,
20
3 GLT.
3 GLT 347.
Noor Begum.
Yes, Noor Begum. NUR Noor Begum. PEGU.
And you are.
Yes, NUR. It will be better 6 now. 6 or 7. No, 6. Now this point is
There's
argued.
one more case on
Yeah.
this. What was it?
Plus,
On oral evidence.
Bijoy Das is also there.
Vijay Das is
Bijoy
there.
Das is the first one, madam. Then Noor Begum. Then another is Asia Khatun.
Okay.
Asia Khatun is madam. Asia Khatun in respect of father.
And what is Rupjan or Rupajan?
Rupjan and Rupajan is with regard to Gaon Panchayat.
Is it Rupjan or Rupajan?
Rupajan, madam.
Rupajan,
Yes,
not Rupjan.
not Rupjan. Rupajan Beg. And that aspect, madam,
That is Supreme Court.
that is Supreme Court. Rupajan is Supreme Court. That, in fact, this honorable court has decided, madam, that it cannot be accepted. The GP certificate cannot be accepted as a piece of evidence. Then honorable apex court says, with some writers, it can be accepted. So 2 writers were given. It has to be contents of the document has to be true. Authenticity of the document is, and content has to be proved on the basis.
Yes.
So that is. Now, minority, another aspect by Learned Senior Friend has argued. With regard to the burden of proof.
Yes.
In that case, minority, Sobanasundra is clear. In fact, Sobananda Sonwal, my lord, para 21 and 22, 24, 25, 26, up to 40, 41. These all things are discussed. It is, my lord, the learned senior friend, it has relied on the judgment. All those are of criminal cases, criminal jurisdiction. And this is not a criminal court. And para section 9 of the Act, my lord, Foreigners Act has clearly says that, with non-obstant clause, my lord, saying that notwithstanding anything contained in the evidence act. So whatever is there, it has to be appreciated as per the section 9 of. What is there in the evidence act, we are not on that. So this issue, it is, yes, this is almost similar to the section 106 of the evidence act. Almost there, but there the first burden is under 105.
Has been
Then-
interpreted like.
Yes. Then only 106 has to be interpreted. It cannot be interpreted individually. 106 is the evidence act for other cases. But here, madam, directly we are concerned with the section 9 of the. Section 9 says, if any case not falling under section 8, any question arises with reference to the act or any other method or direction given thereafter, whether or the person is not a foreigner or is not a foreigner or a particular places or description, the onus of proving that such person is not a foreigner or not a foreigner of such particular places or description, as the case may be, shall notwithstanding anything contained in the evidence act lie upon the person. So it never sits.
Means from the beginning, the burden is on the proceed.
Proceeding. It is from the beginning proceed. That's why, my lord, that is why, but IMDT was set aside. That is the only reason. IMDT initially given burden was given to the state. Then they could reduce, definitely they could reduce. But this burden is, my lord, same. No. In fact, in para 22, my lord, of the Sobanando Sunwal has relied on the earlier judgment of the Honorable Apex Court in Ghosh Mohammed case. My lord. Para 22, I'm reading, my lord, of the Sobanando Sunwal. This is 2005 5 SCC 665, my lord.
You were aware of Ghosh Mohammed.
Yes, Ghosh Mohammed has said burden is on the. So relying that Ghosh Mohammed, para 22 has said it cannot shift. Similarly, my lord, in para.
Another earlier case has been referred of a larger bench, I think. Ghosh Mohammed and the earlier one. Huh?
Pardon. Fateh Mohammed versus Dalian.
Fateh Mohammed.
Yes, 1963.
Yes,
To
63.
yes, AIR 1963 SC 1035. That is so, and it is clearly said, my lord. Para 46, only a single line, para 46. This, which your lordship has rightly pointed out, this were not considered while passing the recent judgment in the Apex Court.
In Rohim.
Rohimal. Para 46 say, to give the exact date of entry into the India, a Bangladeshi national who was illegally and illegally crossed the international border is not only difficult, but virtually impossible.
Impossible. Why should they say?
This is not only difficult, virtually impossible on the part of the state or any authority.
Unless
So,
you're caught in a
yes.
CCTV camera.
and para 26 has clearly said, well, our case is, let them prove. Once they prove conclusively, if they could prove by adducing
Evidence.
relevant and appropriate evidence, reliable evidence, then yes, state may necessary to go for rebuttal, or otherwise it is not necessary. Para 26 said that only. So their duty to prove is first. Para 26, I'm reading again, madam. There is good and sound reason for placing the burden of proof upon the person concerned. Para 26 of the Sobanando Sunwal. SCC.
Yes.
There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. This is not only in India, but entire world. This is. In order to establish what citizenship, normally he may be required to give evidence of number one, his date of birth. This evidence has to be given. His number one, his date of birth. Number two, place of birth. Number three, name of his parents. Number four, their place of birth and citizenship.
Yes. And in appropriate cases,
Yes.
grandparents.
Grandfather. Sometimes the place of birth of his grandparents may also be relevant, like under section 6A(d) of the citizenship. All these facts would be necessarily within the personal knowledge of the person concerned.
Yes.
And evidence on this point has to give evidence given after he has given evidence on these points. After he has given evidence on these points, the state authorities can verify the facts and can then lead evidence in rebuttal if necessary. That is the line. So what is the burden is absolutely on the petitioner.
No, we here, see this 106 argument. If we test this argument, it comes at the chapter 7 of the Indian Evidence Act.
Yes.
Which is on the burden of proof. Now,
Yes.
101 is the first principle laid down.
Yes, ma'am.
How do you discharge the burden of proof?
Proof.
Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts, which he asserts must prove those facts exist. Now, we cannot, you have to read along with section 9. 9 in, not in any ambiguous terms, in very clear terms, has laid the burden on the on the proceeding.
Proceeding.
Unlike a prosecution case
Yes.
in a criminal matter, where the prosecution is required to prove the case, not only prove beyond all reasonable doubt, that is not there at all here.
Yes.
Is not there at all. Only, and even in a case of reverse burden, like a POXO 29 or 30,
Yes.
even then, since a criminal case, foundational facts are required to be proved by the prosecution, then only the aspect of
Rebuttal.
discharging the burden, reverse burden will come. Here, that aspect is not there.
Yeah.
From the very initiation of the reference, the burden is entirely on the proceeding. He files a written statement,
Yes.
followed by the evidence. And only when you think that a case has been made out where an opinion can also be given in favor of the proceeding, you can give rebuttal evidence.
Yes.
That is when necessary. So at no point of time you can say that no 106 was there. So I'm 91 you and 91 says notwithstanding anything in the Evidence Act.
Yes.
Not only 101, it's notwithstanding anything in the 106 also.
106 also.
That is
But
a
it
non-obstante
yes,
clause.
it's almost similar to the 106, not 106.
Not 106.
It's similar to 106.
See, why
That must-
106 has been brought into the statute book in 2000, this Evidence Act.
Yes.
106 is under chapter 7, where it comes under the aspect of burden of proof.
Yes.
Something which is specially within your knowledge, that burden would be upon that fact who would be asserting it.
Yes.
My brother was just, we are just discussing. Suppose two persons were there in a room. There is no evidence of any intruder. One of them is found to be dead. Then in that case, 106 may apply. You may have
Yes.
to explain.
Yes.
If there is no other evidence of anyone entering the room,
Yes.
how did the death
Both
occur?
of you were
The
there.
prosecution has to prove that
Yes.
there was a homicidal death.
First, yes.
There was a death, homicide was there.
And both
There
of
was
them,
no
both of
intruder,
them, both
and
of
they
them
were
were there in
together.
the room.
Thereafter, it shifts.
Yes, both of them were there in the room. Then the burden lies on the better.
106 is that illustration which we studied.
Yes,
So that bus ticket.
Yes.
So exclusive.
So that's why this goes forward.
But this will not
clearly
apply.
state.
Yes.
And on section 9, we cannot forget that section 9 excludes the entire Evidence Act as all, not
Yes,
only
ma'am.
the aspect of
Not
burden of,
only 106.
not everything.
Yes, notwithstanding anything contained in the evidence. So section 9 is independent itself.
But burden has to be proved by preponderance of probability.
Yes, that
Yes.
is preponderance of evidence. But they have to prove it. That
Yes,
must-
okay.
This full court, your lordship has in that, in Imanali 2026 1 GLT 294, that, Rohim Ali was distinguished, my lord. Your lordship has,
What is the citation?
this is my lord 2026 1 GLT 294.
On
Rohim Ali has said, my lord,
DLT 294. Name Iman Ali spelling?
Iman Ali. IMAN, Iman Ali. That my lord, the.
Paragraph?
Para 12 onwards.
Para 12.
12, 13. Para 10 onwards, my lord. This is.
This was the case where Rohim Ali was tried to be
Yes, yes, yes.
distinguished vis-a-vis Sarbananda.
Yes, ma'am.
I think we read somewhere, somebody had written an article on this.
Yes.
Okay.
That's fine.
M.U. Mahmood. Or for the J. Payne. N. Kulita, P. Sharma. And yes, Union of India. Who was there? K. Gokul. K. Gokul. Hearing is concluded. Judgment is reserved. No? Long argument. Okay. Okay. Report. Okay. Yes, next.
I will.
May I please, your lordship? Lordship, opinion, your lordship, is on 35, 2019, your lordship, page,
You are
70,
Rina Rani or Rani Rina?
Rani
Rina.
Rani Dey. After her marriage, her husband's surname has been, your lordship, before her marriage, she was known as Rina Chanda, your lordship.
Now, but Rani has also come.
Your lordship,
Just a minute, just 1 minute. You like to argue on marriage?
yes, actually, your lordship, petition, proceeding exhibited all total 11 documents, your lordship. But the opinion was, without considering the other exhibits, your lordship, opinion was rendered only on the school certificate, your lordship. Although school certificate has been proved by the.
What certificate?
School certificate, your.
School certificate.
And Gauhati certificate, your lordship. Although the.
Opinion is a which page?
Yes, your lordship.
Opinion which page?
Opinion page 75, your lordship. 75 onward. Her written statement and other document has been discussed, your lordship, and the relevant opinions start from your lordship, paragraph 15, your lordship, page 79.
7. Opinion is dated
35, 2009.
19. FT Baksa.
Baksa, your 351, 2017.
Yes, what is your case?
Your lordship, petitioner, proceeding, your lordship, exhibited 11 document, sale deed, registered sale deed, which has been proved by the issuance authority, your lordship, containing her name.
How many witnesses?
With 5 witnesses.
5 witnesses.
Proceeding, her paternal uncle, your lordship.
Just a minute. 5 numbers.
5 now.
And 11 documents.
11 documents, 11 exhibits, your lordship.
Who are the 5 witnesses?
DW1 is the
Proceeding.
your lordship. 2 is her paternal uncle, your lordship, Gaurango Chandra, your lordship.
PW2 paternal uncle.
Paternal uncle. And 3 is the Gabuda, your lordship.
4.
4 is the school master, your lordship.
School master, headmaster.
School headmaster, your lordship.
And 5?
And 5 is the revenue authority, your lordship.
Revenue authority.
Who has issued for proving the sale deed, your lordship.
Okay. What are the documents?
Document exhibit, if your lordship start from page 15, your lordship, is the translated copy, your lordship. I have given
15.
page 15. Here the name of her grandfather, your lordship, Satish Chandra, son of late Ishan Chandra, your lordship. This is the sale deed of 25/4/1957, your lordship.
Between
Satish Chandra, Pita Ishan Chandra, and Gyanandra Chandra Majumdar, your lordship.
Page number.
Page number 15 is the translated.
Satish Chandra Sonda.
Chandra, your lordship.
He is the father of your
Grandfather. Your
grandfather. Okay.
Then your lordship exhibit 2 is the another sale deed, your lordship, where the name of her father along with 2 paternal uncles appear, your lordship. Page 21, your lordship. Nihar Ranjan Chandra is her father, Your Lordship. Narayan Chandra is her paternal uncle, and Sri Gauranga Chandra is her also paternal uncle, Your Lordship. Pita Sri Satish Chandra, Your Lordship. This is between
Date.
date. This is of Your Lordship. Date of 3/7/1967, Your Lordship.
Hmm.
3/7/23 page Macaulay Perez. 3/7/1967, Your Lordship.
1967.
67.
Still did.
Sale date, Your Lordship. Register sale date.
Between
Between
Niharanjan Day. So Niharanjan Chandra, who is he?
along with his two brothers, Your Lordship.
Niharanjan is your father.
Is my petitioner's father, Your Lordship.
Niharanjan.
Yes, Your Lordship. Narayan Chandra is a paternal uncle, and Gauranga Chandra is also paternal uncle, Your Lordship. Between Sri Budman Rabha, son of Shukura Rabha. Then, Your Lordship, Exhibit 3 is the revenue receipt, Your Lordship. The page by her one of her paternal uncle, Your Lordship. Here had his name. This is dated 13/4/1979, Your Lordship.
This certificate copy you have obtained in 2019. This page 22.
Page 20. But the issuing of this has been proved, Your Lordship, by the revenue authority, Your Lordship. TW5.
Exhibit this. 19 or 17 negative, 17 also. 31, 17, 17. Yes. Next document.
Exhibit 4 is the, Your Lordship, total list of
Just a minute. Exhibit 3 is what?
is the Khazna receipt, Your Lordship. Page 27 may kindly peruse, Your Lordship.
Just a minute. 27.
26 is the translated copy, Your Lordship.
Who's the Gauranga Chandra?
Gauranga Chandra is her paternal uncle, Your Lordship. His name appear in the sale deed, Your Lordship, which I have just perused, Your Lordship. Exhibit 2. Then, Your Lordship, Exhibit 4 is the voter list of
This is in respect of which land?
land. So 23 number Prozy land, Your Lordship.
Exxon or Tozi?
Exona, Your Lordship.
And what did you buy by this page 22? Where is the topsil? Where is the topsil?
Topsil, page 21, translated copy, Your Lordship.
No. The vernacular.
Vernacular topsil, Your Lordship.
Where is the description of the land? Mati topsil. Oh, so no.
Bonito Moat. 3 kata, Your Lordship, page 22, may kindly peruse. Last line, Your Lordship. Topsil Bonito Moat, 3 kata, 16 লেসা জমি দায়মুক্ত অবস্থান
Okay.
Then, Your Lordship, Exhibit 4 is the voter list of 1971. His petitioner's father's name appear, your lordship. Here, your lordship, name has been written as Nihar Ranjo Das De instead of Nihar Ranjan Das, your lordship.
1971.
71. I have explained this, your lordship, discrepancy in my written statement.
Ranja Das De.
Son of Satish, your lordship, age
Neha
35. Age 35.
Ranja Das De. Who is your Niharanja Das? Father?
Father, your lordship.
Okay.
Then, your lordship, voter list of 1989, your lordship. Page 31, your lordship. 31. Along with my mother, your lordship.
1989.
1989, your lordship.
Nihar. What is your name?
My name did not appear, your lordship.
Oh, these are your parents' names?
Their parents' name, your lordship. Niharanjan Chandra Chand and Abhirani, your lordship. Son of Satish Niharanjan, my grandfather's name, and against my mother name, my father's name recorded, your lordship.
But your father's surname has changed from De to Chand.
Yes.
Why?
These are the mistake by the enumerators, your lordship.
Father, mother. And from 71 to 89, what happened?
71 to 80.
59, almost 20 years. Where are you in 20 years?
My name, my
No,
father.
where are your parents?
Parents. These are not exhibited, your lordship. I was born, my date of birth is 1973, your lordship, for which my name did not appear along with my father's, your lordship. And to establish my linkage, your lordship, I have.
Your date of birth is there or year of birth is there?
Date of birth, as per my written statement, 1/2/1973.
DOP
1st February 1973, your lordship.
1st February.
February
1/2/1973. Okay.
And to establish my linkage, your lordship, I have exhibited exhibit 6, your lordship, page 33, school certificate, your lordship.
$33.
Here my date of birth is also recorded, your lordship.
What is their school certificate? Ina Sunda,
Yeah.
daughter of Niharanjan Sunda. Left the school left the school on 31/12/1983.
83. This has been proved by the production of school registered, your lordship.
31/12/1983.
83.
And you procured this certificate in 2015.
15, your lordship. Just
Age of date of birth.
establish my linkage, your lordship, since my name did not appear along
Class
with my father.
3. Ill health. You had left because of ill health. How has this been proved, this certificate?
By the production of school registered, your lordship.
School register has produced
Yes.
this school.
Yes.
If it takes long, it may not be able to be taken up. Full FT matter.
FT matter.
Single bench has a more. Now we see a meeting of.
My lord, I have a very small matter, item number 5.
What is it?
My lord, this is an expertise order, my lord. Just 5 minutes submission, my lord. I'll give just 5
Okay,
minutes.
let us write 5.
5, my lord.
19 matter.
Lordship.
You're in interim bail.
Lordship, there is no interim, my lord.
Then
My lord, even then, my lord, this is an ex parte order notice never been served, my lord, and the service report is also there, my lord. Royal Lordship will find that service report at page 22 of the record, my lord. Notice was not served to me, my lord.
Please check the records. Served there. What is the opinion, Mr. Chandra?
Opinion, my lord, that is an ex parte order, my lord. I have been declared foreigner after,
Page
that is page 10, my lord.
10.
Page 10, impugned order.
May I read, Lordship?
Please check up. When did you come to this court?
My lord, whenever I got information that my name has not been enrolled in the NRC, my lord, then I take a certified copy and thereafter I file this case, my lord.
Yes,
Immediately, my lord.
Mr.
Yes, Lordship, notice was not properly served, Lordship. মোতায়েন কৰা মতে আমি 6-10-2018 আৰু 19-18 তাৰিখে নিচনামাৰী গাঁৱলৈ গৈ গাঁওবুঢ়াক লগত লৈ গাঁওখন তদন্ত কৰি জাননীত উল্লেখ থকা ঠিকনা মৰ্মে ব্যক্তিজনক বিচাৰি উলিয়াব নোৱাৰিলো। কিন্তু তেওঁ আগতে এই গাঁৱৰ বাস কৰিছিল যদিও বৰ্তমান উল্লেখ কৰা ঠিকনা মানুহ কোনো নাই। সেয়েহে আমি গাঁওবুঢ়াক লগত ৰাখি দুজন সাক্ষীৰ সাক্ষাতত জাননীৰ নকল কপি নিচনামাৰী গাঁৱত থকা দুৰ্গা
Why is
মন্দিৰৰ
it pending for so
সন্মুখত
long from 19?
In the temple.
Yes, Lordship.
No, it is affixed on
Uh,
the
bu- bu-
fee,
bu-
my lord.
Yes,
We'll
Durga Mandir সন্মুখত
dispose this of.
Yes, Lordship.
Heard. Unnecessary curiosity. Heard Sri B. Chandra Learned Counsel for the petitioner. Also heard Sri So-and-so. Para. The instant application under Article 226 of the Constitution of India has been filed challenging an opinion dated so-and-so, passed by so-and-so, in case number so-and-so, whereby the petitioner has been declared a foreigner post 1971, full stop. The primary ground of challenge is that the impugned opinion has been passed without giving the petitioner an adequate opportunity to defend himself or herself.
He himself.
Himself, full
Himself,
stop.
my lord.
Full stop.
Vidur Das.
Para. Sri Chanda, the learned counsel for the petitioner, has drawn the attention of this court to the specific pleadings made in paragraph 7 of the petition, of the writ petition, and has contended that at no point of time any notice of the proceeding was served upon him, full stop. He has also referred to the observations made by the learned tribunal that notice was served upon him in the manner provided under the Foreigners Within Bracket Tribunals Order 1964. Full stop. He submits that such observation is perverse and is not and accordingly not sustainable. Para. Not para. He has also submitted that the records would also fortify his submission. Para. Sri G. Sharma, learned standing counsel, Home and NRC, has fairly submitted that from a perusal of the records of the tribunal, it will not appear that the notices were served in the manner prescribed by law. Full stop. He submits that there is a report of the Jari Korak that the notice was served in a temple. Correct?
In front of a tree.
Affixed in a tree in front of a temple.
Yes,
Full stop. Para. The aspect, the aspect of service of notice is clearly laid down. Clearly laid down in the. We have just written a detailed thing. I've also quoted, in the Foreigners Within Bracket Tribunals Order 1964, and the relevant provisions are extracted here in below. We have just given an order. You'll extract 3 within bracket 5, then A, B, C, D entire, 3, 5 entire, huh? Full stop. The the aforesaid provisions have contemplated all situations how notices are to be served, which also includes a situation where a proceeding is not found in the last known address. Full stop. The mode of service of notice in the instant case does not appear to be in consonance with the prescription of law. Para. In view of the above, comma, a case for interference is made out, and accordingly, the impugned opinion is set aside. Full stop. The matter is accordingly remanded back to the learned tribunal, fixing the date as 15th of June 2026, on which date the petitioner is required to file the written statement along with all the evidence in chief. Full stop. The learned tribunal would accept the same and take charge of the proceedings from that date. Full stop. The learned tribunal would also endeavor to complete the proceedings in accordance with law and as per order 3 within bracket 14 of the aforesaid orders of 1964. Para, records be sent back 4 weeks.
Obliged.
May I plead your lordship? That's item number 13. In this matter, I have annexed some document which are not certified copy. Lordship, kindly allow me 2 weeks time to annex the certified copy, Lordship, by way of affidavit.
Certified copy were produced before the tribunal or not?
Lordship, these are exhibited before the tribunal, but which I have annexed are not.
Doesn't
certified.
matter, we'll check from the records. We'll check from the records. Will not cause, this will not cause any prejudice to you.
No.
Records are there before us, okay? Rest, court master will give dates.
Wait, please, Milos.
Yes.
Just a small request, Milos. In item 33, Milos, the
Right.
habeas corpus petition. So the facts are admitted.
33, what is your case?
33, Milos, is an habeas corpus petition. The issue is whether my detention was legal. So the police have accepted that I was arrested on the 1st of November 2025, and I was released in the evening of the 3rd of November 2025, Milos. He's an Indian citizen, and there is no preventive detention order passed by any executive magistrate. So the rigors of the BNSS apply in this case, Milos. The
So
police,
why is it for orders, Mr. Banerjee?
Milos, I believe all compliances were made.
No,
So-
why is it for orders?
Milos,
Is it for orders? Maybe
yes.
maybe some service is to be done or something is to be. Have you checked the records?
I've complied with everything. I've applied for an application for listing, Milos. The listing was supposed to be under the admissions column. However, it's placed in orders.
We can have it on a date, day after tomorrow,
Milos,
on Wednesday.
Milos, I'm pleased, Milos.
It Wednesday, paucity of time, huh? Will not permit this matter to be taken up today. On request, list on Wednesday. This will be item number
33.
33. Okay.
I'm obliged, Milos.
Rest, if there is urgency, he'll give dates. Otherwise, also 19 matters, we'll give early dates. Single bench will sit within 10 minutes.
May it please your lordship. I'm appearing on behalf of P. Chariya. Lordship, as per the order, opposite party has filed written objection. The objection may be come on record.
When the
Today, lordship.
today,
Yes, lordship.
where is Madam Paul? Name,
Lordship, it's a review matter.
where is Madam Paul? J. Paul. Okay. The learned counsel representing the applicants has, what is your name? We record your
DN Das, D
DN.
for Delhi.
Miss D.N. Das, learned counsel representing the applicants has submitted that written objections by the opposite party has been filed today with copies served upon her. Full stop. The objection, however, has not been tagged with the records. Full stop. Further, there is no representation on behalf of the respondents, though names are appearing in the cause list para. In the interest of justice, matter is adjourned adjourned to enable tagging of the objection with the records. Full stop. The same is to be listed as and when this bench is available.
Bless you.
Item 2.
Item 2. Anyone from the Forest Department? None appears for the parties on call. Para. In the interest of justice, matter stands adjourned to be listed as and when this bench is available.
Actually, item 3.
What is it matter of finance department?
Maybe. My lord, this is, my lord, IA for consideration of delay of 334 days in filing the, my lord, review petition. Now, last 2 occasions also my friend was not available, my lord. Today it's also, oh, my lord, pro video conferencing, my friend is available.
Yes, Mr. Nayak. Yes, Mr. Nayak. Please unmute yourself. Oh. Network issues.
This is a
Mr. Nayak, there are some network issues. We can have it on any other date. Though you are visible, you are not audible. We
Yes.
cannot hear you.
my lord. And if, yes, I'm audible, Lord,
No, there are
Hello?
network issues.
Lordship, Lordship.
We'll have it.
Otherwise,
any
I
other
am
date.
listening you, your Lordship.
Oh,
No problem.
slow है से network क्यों? बहुत. Oh. Oh. There is some issue on your network. It's very slow. We can have it any other day.
Lordship, Lordship.
Though heard Sri MU Mondol learned counsel for the applicants. Also heard Sri P. Nayak. Learned, you appear as what? AG. AG for the state who appears online.
Yes,
However,
Lordship.
there being certain network issues, comma. The matter is adjourned to be listed when? To be listed as and when this bench is available.
Any convenience day, your Lordship.
Convenient day we cannot say. This bench is not there, single bench. Madam, you are not there.
Obliged, Lord.
Okay. You have filed your objection.
Yes, Lordship.
Okay, last part to huh? Let your objections come on record.